Welcome, everyone. We are excited to have you all here today. My name is Heather Ware. I am the Legal Advocacy Program Coordinator with Whiskative, and we're very excited today to be hosting this webinar about advocating for victim defendants. This is something that we heard from a lot of advocates in the legal advocacy survey last year that they wanted more support around. And so really glad that it worked out to bring this content to you all and the survivors at your programs.
I introduced myself earlier. I'm Deidre. I work at the Coalition, and I do most of my work centers around management, leadership, and advocacy support. If you ever have any thoughts or questions or things you want to sort of sort through, please give me a call. I'm always willing to help. I love doing TA visits. Now they're virtual TA visits, but yeah.
Well, we can pass it over to Cindene.
Okay, great. Thank you very much, Heather. Hi, everybody. My name is Cindene Pezzell. I'm with the National Clearinghouse for the Defense of Battered Women. We are in Philadelphia. So greetings from across the country. Anyway, if you want to know a little bit about me, there's some information in the PowerPoint. But the short story is I coordinate the legal team here at the National Clearinghouse. I do a bunch of trainings. I do work with expert witnesses. I give direct TA to lawyers who are working with victims who are also defendants. And as I said, I'm happy to be here with you today. Coming to this work, I brought several years of experience as a public defender. So really my whole career has been focused on criminal defense issues, and I'm excited to talk about some of them with you here today. I'm not sure how many of you have worked with us in the past, but as I said, we're located in Philadelphia, and we love working with advocates who are supporting survivors who are charged with crimes. And we do that by talking about really solid advocacy strategies that don't compromise people's legal rights and options. We talk with people about working with defense attorneys and, just really making sure that everything about a survivor's criminal case is designed to reduce the amount of time or to minimize the amount of time that she's involved at all in the system as a defendant. So after we conclude today, I hope to hear from all and any of you if you're interested in learning more about institutionalizing defense work at your program. I know a lot of programs in Washington State already do that. Or if you're working on a specific person's case and you want to talk through some things or have us connect with the defense attorneys, please reach out. My contact information will be in the PowerPoint, and I would love to hear from any of you. So today, we've got a lot on the agenda, and we're going to get to what we can, but really I want this to be something that is relevant to all of you. So to the extent that you have questions or that you want to discuss a certain area related to criminal defense and victims charged with crimes, please type that in the chat box and we'll do what we can to address it, because this really needs to be about what you're here for and not just what I'm here for. That being said, we're going to talk about some ways that victims of interpersonal violence, who, as you all know, are already incredibly marginalized, become much more oppressed and marginalized when they're involved in the criminal legal system as defendants. We're going to talk about some of the ways that victims end up arrested, charged, and incarcerated in the first place. As I said a little earlier, we'll talk about some strategies for advocating for people in this situation and talk about how we can break down some of the things that really get in the way of working with victim defendants. And just so everybody knows, I've really welcomed Heather to interrupt me if something comes up in the chat box and I don't see it, because as I said, this I'd really love if this were more of a conversation than, you know, than me just talking at you. So please don't hesitate to bring up issues if you want to talk about them. So to frame this discussion as we move forward, I just want to have some clarity around language, because as we see in so many different spaces, the criminal legal system tends to have really different language than what we use in the anti-domestic violence movement and in other places in our work. So when I say the word victim, I'm talking about somebody who has experienced intimate partner battering, regardless of their position in the criminal legal system. To refer to a what often gets called a victim, a witness on behalf of the prosecution, I'll refer to those people as complainant or complaining witness. It's important to make this distinction because people who worked really close to or adjacent with the criminal legal system, especially if they're working with survivors whose abusive partners are being prosecuted, often have the term victim ingrained as a position in the criminal legal system. And what we know is it doesn't matter where you're sitting in the courtroom in any given case. Anybody sitting anywhere could be a victim of intimate partner violence. So to stay on the language theme for a minute, I just want to quickly talk about some of the burdens that victims charged with crimes have to carry. And to do that, I want to just throw out some adjectives that get attached to people regardless of context and regardless of the true experiences of anybody's individual life. And I'm not talking about people on this webinar necessarily, I'm talking about out there in the world, okay? So when somebody's charged with a crime, there's a lot of language that gets attached to that pretty much automatically. And we see this over and over again in news, in media, in conversations about what's happening in our communities. People who get arrested and charged with crimes are often immediately labeled with the term suspect or offender, and this is, not a great thing in any circumstance, but when you're dealing with somebody who hasn't even been convicted of anything, you can see how it sets up biases and expectations about who this person is and what he or she has done. And these labels carry through whether somebody gets convicted or not. But people who have records are criminals or offenders or, ex-offenders, which is supposed to be better language in some kind of way, which really isn't. And then, we have the presumption of innocence in our American legal system, but in a lot of cases that really is a little bit of a fiction. I think it's fair to say that, in our culture, the presumption of innocence is just not as strong as the presumption of guilt for when somebody gets wrapped up in the criminal legal system as a defendant. Victims of intimate partner violence have a similar phenomenon that happens to them. Once their experiences of abuse are revealed by them, or whether that's in court or in life or wherever it is, there's definitely some labels that automatically get attached to people, again, regardless of their individual circumstances. And everybody on this webinar knows this from the survivors that they've worked with. As soon as anybody mentions their experiences of abuse, there's questioning that happens. There's interrogation of the credibility that happens. And this is, like I said, without even any context thrown in there. People in this world are so tempted or so drawn to disbelieve a victim's experiences of abuse. And I think there's a lot of reasons for that. We'll talk about some gender stuff. You know, there's racism involved in there, but also it's just the fact that people don't want to believe the terrible things that happen to people happen like that and happen all the time. So a lot of these labels that end up getting attached to victims undermine their credibility in a major way. So take those two sets of labels that automatically get applied to defendants and those that get applied to victims of battering and put it together, and you have a real mess. Because now you have somebody who's not only having to fight for their freedom and, you know, fight for the truth in the criminal legal system, you have somebody who has to do that under the burden of all the disbelief that comes with people expressing their experiences of abuse. So what we see over and over and over again is that victims who are also defendants don't get to count. And I'm using air quotes for if anybody doesn't have access to the visual here. But because real victims don't do things, right? Like get arrested. They don't do things like end up in jails and prisons and that kind of thing. A common theme that we also hear is that if people bring up their experiences of abuse as defendants, they're trying to do it in order to game the system. Oh, I'm going to say I had battered women syndrome and that's going to help me win my case somehow, I guess, is the idea behind all that. Which is a phenomenon, you know, known as the abuse excuse, which is, you know, that's one of those funny, not funny things, because, you know, if victims who get arrested for defending themselves against their abusive partner were wildly successful with this abuse excuse, I think we'd be seeing it a hell of a lot more often than we actually do. But the fact of the matter is that once people get arrested for self-defense, you know, it's pretty hard to exit the criminal legal system completely vindicated, and we'll talk about that a little bit more later. So again, these stereotypes and labels come together to really undermine where a victim defendant is starting in terms of her veracity moving through the criminal legal system. In other words, no matter how his or her defense moves forward, no matter what it is they say happened, it's going to be met with doubt. Is that true for all defendants? Yeah, most of the time. But I'd say that victim defendants have an extra burden here, an extra burden around being believed about what had happened to them and what happened during the incidents for which they got charged. So to, you know, debunk a lot of the beliefs about what a real victim defendant might look like, you know, we kind of list some traits that we see in our work overall about who counts as a victim and who doesn't count as a victim. I mean, those same things really do apply to people who end up charged with crimes, okay? So the myth of the real victim defendant is definitely the Lifetime television for women version of a defendant who is quiet and small, has never been into trouble, and doesn't cry too much, but doesn't cry too little either, who relies on the police and believes the police and trusts the police, and is able to know that her experiences of abuse and her narrative about what happened to her is going to be believed. But we know that there is no typical victim defendant. Just like all the victims we work with, we see these victims encounter challenges to whether or not people believe in their experiences. And this might happen because they're angry. This might happen because they have a criminal record, or they appear to be somebody who can hold their own in the fight. Maybe they even can. Maybe they have violent crimes on their criminal records. These are all things that really, really get in the way of people believing victim defendants. But the fact of the matter is that these are the real people that we see day after day after day. And none of these characteristics about a person negates the reality that they are experiencing intimate partner violence. And so when we have people who have to show in court that what they did was self-defense, or that they did it under duress, or that they did it trying to survive their abusive situation, this false information about what victims should look and act like can really, really get in the way. So the credibility challenges that are always present for people who experience intimate partner violence, there's another dynamic that comes into play when people are defendants too. We know that people who have experienced trauma exhibit certain behaviors sometimes. The problem is that oftentimes those behaviors are the same ones that people within the criminal legal system and within our communities equate with deception and lack of veracity. I know, for example, we know that when people are recounting a traumatic event, sometimes it's really hard for people to tell their stories in a linear fashion. And that's the exact same kind of thing that police officers will describe on forensic files or cold case or whatever it is. That same behavior gets interpreted as somebody who's making up a story as they go along. Victims of intimate partner violence also can't seem to perfect the appropriate emotional response. And what I mean by that is people credibility gets undermined if they're too emotional, but it gets undermined if they're not emotional enough. I worked on a case several years ago where the victim defendant's credibility was being questioned because she ate a granola bar during her police interrogation. I don't know. I don't know what that has to do with anything. But for the way that people respond, it's really hard for survivors to hit that sweet spot where they're going to be believed. And if people are experiencing trauma, they might have a flat affect, or there might be inappropriate laughter, quote unquote inappropriate laughter. These are all the things that can cause people to disbelieve victims, but they're trauma responses. And sometimes victims don't have a paper trail. Most of the time, victims don't have a paper trail. But for whatever reason, in the criminal legal system, hospital records and protection orders seem to be the most revered kinds of proof that abuse happened, even though most victims simply don't have those things. So credibility, I've talked about quite a bit. Legal relevance of experiences of abuse, we'll get into that. All I mean by that is victims are challenged as defendants because the most relevant things to describe the incident that they got charged for are often the kinds of things that judges want to keep out of court, okay? So when I say that, you know, victim defendants have specific challenges, they do. Do all defendants have them? Yeah, but it's a real extra uphill battle for victim defendants. There's safety implications here too. And just very briefly, when defendants are involved in the criminal legal system, there is ways in which their safety is even further compromised by their abusive partner. If somebody is on bail or on probation or on parole and therefore under state control, that can very quickly turn into a very powerful weapon that can be wielded by somebody's abusive partner. Abusive partners can get people in trouble for violating bail conditions, whether they did or they didn't. You know, what we've seen, it runs the gamut. Abusive partners coercing the victims into drug use and then calling the probation officer who's supervising them, forcing people to miss court dates, reporting abusive incidents that never happened to probation officers, that kind of thing. Some people have very big restrictions placed upon where they can and can't go when they're on bail or probation or parole. So people on electronic monitoring may not be able to leave their house. If they live with their abusive partner, of course, that could be really dangerous. They may have to make a decision between getting in trouble with the police and getting in further legal trouble, or facing the danger of their abusive partner. But also, if they don't live with their abusive partner is gonna know where to find them if they're on electronic monitoring. So that can raise danger significantly for people. And that danger is even greater when that abusive partner is the complainant in the criminal legal case. Making promises in exchange for demanding sex or demanding drug use or demanding money or whatever it is, making promises and threats about what will or won't happen with the criminal court case is also a real powerful tool. I can't tell you how many times we've heard survivors tell us that they took a plea deal because their abusive partner made them do that, or they didn't show up for court because their abusive partner wouldn't let them, or they lied on the stand because they were afraid of what might happen if they didn't. So in addition to the legal risks, in addition to the undermining of credibility, somebody's very well-being, their bodily well-being, gets very compromised if they're abused and also involved as a defendant in the criminal legal system. If somebody, this is speaking of Connie Burke, whose name came up earlier, this is something that I've heard her talk about a few times. If there's two houses next door to each other and domestic violence is happening in one house and it's not happening in the other house, police intervention is much more likely at the house where domestic violence is happening. And what this means is, whether you're perpetrating abuse or experiencing abuse, if that's happening in your house, your likelihood of interacting with the police and getting arrested goes up exponentially. In other words, getting battered is a risk factor for arrest. And it's not just because of where the police may or may not show up, okay? It's also because a lot of the things that victims are forced to do sometimes in order to survive are things that are criminalized. So it's not just cases, right, where victims have to physically defend themselves against their abusive partner, although that is a lot of cases. There's so many things that really just have to do with survival. And if an abusive partner is demanding money, then that person's abused partner may do what he or she has to do in order to make sure that money gets produced from somewhere. We know that a lot of survivors are trafficked. We know that a lot of survivors are sex workers, and we know that a lot of times they may not have control over where that money ends up. In other words, the things that they are criminalized for are things that they are doing because that means they're going to survive. So not all of these strategies of survival or these ways that survivors get criminalized are necessarily going to be an easy path to follow, A to B to C. She was being beaten up, so she grabbed a knife and she used it in self-defense. There might be a roadmap there that's really hard to see until we dig a little deeper. But in the end, so much of what people do that lands them in the criminal legal system, they do because it's a way to survive. I mean, and that's true in the context of domestic violence, but that's just true in the context of getting from one day to the next for so many people, especially those who have to battle things like racism and heterosexism every single day. Another one of the ways that survivors might find themselves in the criminal legal system as defendants is the role that substances may or may not play, either in the way that they're, getting money for their household or complying with the demands of their abusive partner, or the ways that they're coping with the abuse and trauma. We know that, a lot of people who use drugs do so as a way to self-medicate. So again, just another way that trying to survive and try to make it from one day to the next ends up being because of ends up being something that's actually a criminalized activity. And I don't want to imply or say on this webinar or anywhere else that victims of intimate partner violence are the only victims of trauma in our courtrooms and in our jails and in our prisons. It's just not true. Almost all defendants have experienced trauma of some kind or another, whether that's intimate partner violence, whether that's trauma that comes from poverty, whether that's trauma that comes from historical and current experiences of racism, whether it's trauma that's come from being over-policed in one's own neighborhood and over-surveilled, okay? So one common denominator of people who end up filling our jails and prisons are the ways that these experiences of trauma and abuse play out and end up being criminalized. So I do this to say explicitly that I'm not trying to put survivors of domestic violence out there as being the ones who should get a special set of rights and a special set of circumstances and a special way that they're treated as they navigate the criminal legal system. I'm not saying that at all. What I'm saying is that domestic violence victims may have experiences of abuse that directly inform how their criminal court cases should be navigated in order to get them out of that criminal legal system as soon as possible. One thing that we can't do, and that I think the way that the criminal legal system is set up, it ends up being a little bit counterintuitive, but we can't look at a list of behaviors that are behaviors of survival and know whether or not those behaviors are going to be legal or illegal. Just like we can't look at a list of behaviors of oppression and know whether or not those behaviors are legal or illegal. As everybody knows, if they've worked with a survivor who has been stalked, for example, the vast majority of things that someone who stalks someone else does is probably legal. It probably, individually, those things don't meet the definition of any crime. And yet, we know that if somebody is stalking somebody else, they're engaging in a very deliberate reign of terror against that person. So legal and illegal are not the most helpful guides for when we're trying to decide whether or not somebody is experiencing abuse or whether or not somebody is using abusive tactics to harm somebody else. And along those same lines, whether or not somebody's arrested or whether or not somebody is a complaining witness does not give us the information we need to know, A, if somebody is in an abusive relationship, and B, whether they are abused and battered in that relationship or whether or not they're the ones doing the harm. Position in the criminal legal system just doesn't tell us that. So I've already brought up self-defense situations. I think that's probably the most common case that we work on here at the National Clearinghouse. But these, there's the capital self-defense, SD self-defense, where somebody's defensive actions against their abusive partner can meet a legal definition of self-defense, meaning that their perception of danger was reasonable and that the threat to them was imminent and that everybody's going to understand what that means for them. And then there's a lot of people involved in the criminal legal system whose self-defensive actions aren't necessarily going to meet any legal definition. And those are cases that we've all seen, such as where a victim might initiate the abuse so that he can get it over with, or a situation where it appears from the outside looking in that the force somebody used to defend themselves was disproportionate, having a weapon and the other person not having a weapon. But self-defensive actions that somebody undertakes to try to stay unharmed, to try to stay alive, are a big category of the cases that we see when victims get charged with crimes. Victims also get forced to participate in criminalized activities by their abusive partners. The umbrella term that we use for that here at the Clearinghouse is duress. And duress is so interesting to me because during my years as a public defender, my understanding of duress was very narrow. Basically, in order to launch a successful duress defense, we had to be able to prove that somebody, participated in illegal activity because there was a gun to their head, quite literally. When I started to learn more about domestic violence is when I learned that people on the outside looking in, people may not be able to see that gun to the head or to see that knife to the throat, but victims know that it's there. They know that it's there because in the past they've faced severe consequences for not submitting to their partner's attempt to coerce and control. Even if the abusive partner isn't present, the danger is still very real. And so if somebody participates in a burglary or a robbery, or somebody is involved in some other kind of economic crime, it may be because the alternative to doing that was so much worse than the legal risk. One case that is kind of case that is always tricky because it's really hard to defend against a negative are the cases where abusive partners know how to leverage the criminal legal system and are able to fabricate false charges in order to further harm and control and abuse their partners. I remember when I was a public defender, I had a case where my actual defense was that the complaining witness had punched himself in the face, okay? And, I interviewed my client. That's what she told me had happened. I told her nobody was going to believe that because people don't punch themselves in the face, giving them a lot of injuries around the orbit and the black eye and everything else. And she's like, well, that's what happened. And I asked her, I suspected something was going on. And so I asked her if it was a self-defense situation. And she said, Cindene, no, he punched himself in the eye. So I said, if we use that as a defense in court, nobody's going to believe you. She's like, well, I'm going to because that's what happened. So I'm putting up this trial that I thought was going to be a self-defense case, and it was actually a fabrication case. And at one point, the complaining witness's father got on the stand, and the reason he was being called as a witness is because he's the one who called the cops. And my client was like poking me and asking me about, ask dad if his son punches him in the face. And I'm like, fine, okay. So I asked the witness, does your son punch himself in the face on a regular basis? And he's like, yeah, he does that sometimes when he's trying to get attention. So, that was my lesson learned at the time, and all of you knew that way before I did, but yes, in fact, abusive partners will harm themselves or compromise themselves legally if it means being able to exert coercive control over the partners that they batter. And in this particular case, he wanted her to get into trouble, and he wanted her to be placed on some kind of probation so that he would have a bit better chance of knowing where she was at any given time. I remember after this case, she was convicted, by the way, but after this case was over, you know, she would call me and tell me that he was texting her and calling her 100 times a day. Eventually, she was able to get out of that relationship, but not before she got a conviction for assault because of the lengths that this guy was willing to go to get her into that kind of trouble. I don't know if it's commonly charged in Washington, but a lot of victims face parental kidnapping accusations when they leave an abusive situation in order to protect their children. On the very flip side of that, we see people charged with failing to protect their children for not removing them from an abusive situation. So victims with children find themselves in this very precarious catch-22. You know, should they stay in an abusive situation where their children may be harmed and risk being criminally charged with failing to protect, or should they take those children and leave and face being charged with depriving the abusive parent of their rights to those children? It's a catch-22, and fortunately, at the Clearinghouse, we're hearing about that one a little bit less than we were in the past. People, I would say the majority of victims who end up involved in the criminal legal system don't get there because of these very direct connections between what they're accused of doing and their experiences of abuse, but based on something a little bit a little bit harder to define and a little bit more difficult to put in the very difficult box that the criminal legal system expects you to. Again, survival strategies, people who self-medicate, people who drive drunk because they need to get away from their abuser, people who need to resort to theft and bad checks and other economic crimes because they don't have access to their own money. In these ways, people who are being battered often also end up in the criminal legal system. And all of this is to say that so many people who need the support and services of anti-DV programs are people who have been criminalized, and that people's experiences of ending up as defendants doesn't change anything about the fact that they're victims and the fact that they may need services and support and safety in the exact same way as people who are not criminalized. Defense-based advocacy is a concept that describes the work that is done with victim defendants in ways that are designed to maximize the effectiveness of legal strategies, to minimize the potential detrimental consequences, of working with an advocacy program while facing criminal charges, and to prevent further victimization of arrest, convicted, and incarcerated victims of battering. So what this means is that advocates, I just dropped my mouse. Advocates who work with defense attorneys have a mandate to coordinate their efforts to make sure that the ways in which they advocate for victim defendants do not undermine those legal rights and options in any way. This approach, requires that advocates have their head around some of the basic tenets of criminal defense. And the reason is not that advocates need to completely, need to be on board with the idea that the criminal legal system is going to produce justice. I definitely wouldn't necessarily ask anybody to do that. I think, you know, we know from our own work with victims, and we know from you know what's going on in the world that the criminal legal system is not particularly well equipped to deliver any kind of what we think of as justice. But that being said, there are some tenets that if we embrace them, it can increase the possibility that the defendants that we work with get out of that system as quickly as possible and with as little harm as possible. First of all, when we're working with from a defense-based perspective, the belief in the fundamental right to due process for all defendants is vitally important. You know, this belief is just saying, I mean, it reflects an understanding that we know that the reason that all defendants have due process is because they're thrust into a system where the other side has all the resources and the other side has all the tools. And so in order to counterbalance that, these constitutional rights come into play: the right to remain silent, the right to effective counsel, these kinds of things. You know, when anybody comes up against the state, you know, even somebody accused of battering their partners, the playing field is not something that is even. And so lifting up and holding up and supporting and believing in these constitutionally mandated rights for all defendants becomes one of our most effective tools. One of those rights in particular is the presumption of innocence. And when working from a defense-based perspective, it's just so important to center the presumption of innocence, okay? Everybody who gets charged with a crime walks through those doors with a clean slate. And the reason that that's so important is because it means that the state, the government, whoever the accusing party is, you know, it could be a state, it could be a county, it could be a tribal nation, it could be the federal government. You know, they have to prove that what they're saying that person did, that they actually did. They have to prove it, and that's because it should be hard to deprive somebody of something so basic as their freedoms and their liberties. It should be something that takes a lot of work to do, and that's why the presumption of innocence has to be our baseline. I mentioned the right to effective counsel earlier. The right to having a lawyer is also something guaranteed by the Constitution. And it's not just having a lawyer, it's having a good lawyer, because when you have a good lawyer, what that means is that the evidence the state is putting forth is actually going to be challenged in a real way, if that's appropriate. Does this always guarantee that people end up receiving fair treatment in court? No, but it's another it's another tool in our toolbox to try to make sure that happens. And I'm talking about all defendants here and not just battered defendants, because that's the premise that we have to work with. You know, if we're going to work adjacent to or within the criminal legal system, it's important that our advocacy and our language and the work that we do isn't built around the idea that there's such a thing as good defendants and bad defendants, right? And that's true in all the work we do. Good victims, bad victims, that's a really dangerous binary to make. And the same is true with defendants. Yeah, there are people who have done things that are terrible. There's people who have preyed upon the victims that we work with in a major way. But if we're going to engage in defense-based work, the same rights have to apply to everybody who's involved in that system. Sometimes doing defense-based advocacy as part of a legal team, you know, there's ways in which that work can go against the grain for advocates sometimes. And that's because advocates work with victims in order to be supportive and in order to hear their truth and in order to give them strategies about how to stay safe. And you know, and to do that, advocates have to let victims be in charge of their own lives, right? Victims are always the experts in their own lives, and they know better than anybody else what kind of help and support they need, what kind of help and support and intervention they don't need, and what choices are right for them to get from one day to the next. Sometimes that's not felt you know, as an underlying principle when it comes to a criminal case. There are situations where the defense attorney might appear to proceed in a way that the advocate wouldn't, because the advocate is directed by the survivor. And some, you know, sometimes that cuts against the grain. And I'll get to a couple of examples of that. But there are often some legal implications and detrimental impacts to some of the ways in which we want to advocate for somebody that can really put somebody in legal jeopardy if they're not done under the direction of the defense attorney. So although it can get really hard when it comes to navigating the way that a criminal case proceeds, it's really important to be attorney directed in these situations. And like I said, we'll give some specific examples of that. One specific advocacy plan that, you know, we've been talking about here more and more involves work that would be good to be done with all survivors who work in your programs. Again, whether they've had any interaction with the criminal legal system or not, people need to know their rights in the event of an arrest. More specifically, they need to know, and this is information they may only be able to get from you, they need to know what's going to happen if they find themselves involved in a situation with the police. Okay? There's been more talk about knowing one's rights, you know, the right to remain silent, for example, lately because of the protests that are happening around the world. Organizations like the ACLU and the National Lawyers Guild are making sure that resources that inform people about what they do and don't have to do if they encounter the police are even more widespread than they were before. So it's important to do safety planning with people around the exercising, excuse me, of these particular rights. One thing that I've been wanting to put together for a long time is a victim, you know, a domestic violence victim specific Know Your Rights guide. Because what is out there in the world is commonly in the context of people getting arrested for protesting or for performing acts of civil disobedience, but the dynamics are a little bit different. If there's an abusive partner on the scene, or if the abusive partner is talking to the police and the victim doesn't want to, or if the victim does want police involvement and intervention but is afraid of getting arrested. So safety planning around that eventuality, whether somebody's involved in the system or not, can be a really, really helpful tool for a survivor to have. And part of that involves what to do if the survivor ends up getting arrested. You know, having a plan for bail, having a plan for the children, having a plan for notifying employers, that kind of thing. If these things are all in place before anybody gets arrested, then it's going to be a much smoother situation, and even more importantly, the survivor is going to be able to with a little bit of information and being able to avoid the panic that comes from complete disorientation and mystery, that's going to allow that survivor to advocate for herself a lot more effectively. So this pre-arrest safety planning with all the folks we work with is really important. Once somebody is involved in the criminal legal system, however, the sooner that they can be identified by anti-domestic violence folks, the better, because the sooner they can get out of jail or out of the system, the better. And there's a few ways that anti-DV programs and anti-sexual assault programs can make sure that they're getting to victims as soon as possible. One way is to, if I know it's a long shot in some places, but for programs that can collect calls from incarcerated victims, that can be the difference between a victim reaching services and support and a victim sitting in jail and feeling completely forgotten about. So if that's something that a program can become set up to do, that can go a long way. What I don't have on this slide, it might be somewhere else, but which I want to talk about now, because in today's world, it's so much easier to find, are bail funds. So if I would have talked about this, before Memorial Day of this year, I would assume that a lot of people on the call didn't know of any individual bail fund, or maybe never even heard the term bail fund. But after the killing of George Floyd, I've heard in so many corners of this country that bail funds are either being amplified in a way that they weren't before, or they're being set up. So in a lot of communities, there's multiple options for places to go to try to get organizations to bail folks out of jails and prisons. And it's not just for protesters. That was the seed that got planted that resulted in so many new bail funds, but these bail funds are, in general, they're there to get people out who are being held pre-trial simply because of the fact that they can't afford to make bail. As a matter of fact, there was a woman who was released 2 days ago. She's been in pre-trial incarceration for 2 years, accused of killing the person who trafficked her. And a bail fund that made a lot of money through donations when protests were happening in Chicago ended up posting bail for her. So bail funds can be a real saving grace for survivors, because fighting your case from the street is so much more effective, quite frankly, than trying to work with your lawyer to fight your case while being held in jail. Early identification, again, can make a huge difference for people. Sometimes we don't hear about cases until right before they're going to go to trial. But if anti-domestic violence practitioners are involved early, they can give that support early, and they can help people be in a good place to make decisions early. They can be a support for when the prosecution is offering a plea bargain that they don't want to take, that kind of thing. The earlier we can get to people, the better of a time they're going to have making decisions and moving from one stage to the next. Another way to make sure that early identification happens is making sure that information about domestic programs is in every county jail and every detention facility and every prison. The kind of information that ends up on court boards, in prison and jail law libraries, next to drug treatment programs, next to social services programs, needs to be the anti-domestic violence information, for a couple of reasons, not just for the very practical matter of making sure that folks know about you, but because having information in jails and prisons says to people who are doing time on the inside, yes, our services are for you too. I've worked with so many defendants who are told from the moment that they're arrested that they're the perpetrator, that they're the felon, that they're the abuser, okay? And so if you're told by a system over and over again that you're in this group over here, the one that's not entitled to nor in need of support and services, you might not doubt that. You might not doubt that. You might buy into the system's definition of who you are and never suppose that an anti-domestic violence program is there exactly for people in your situation. So having that information to people on the inside, being explicit about working with defendants, with prisoners, with people with records, with people with warrants is huge. It's huge to be explicit about that. One of the advocacy strategies that I alluded to earlier, where sometimes, you know, it can feel pretty much like you're not doing survivor-led advocacy, is this one. And this is maybe one of the more important advocacy strategies we have for folks who work with defendants, is avoiding discussing the facts of the defendant's criminal case. And as I said before, this is one of those situations that can really go against the grain for people. And that's because advocates are so used to, you know, and as they should be, so used to encouraging and supporting survivors and telling their stories and talking about what happened to them, and giving whatever kind of narrative and detail a survivor wants. But when a survivor is charged with a crime, it's really important to avoid talking about the details of the incident that gave rise to those criminal charges. And there's a couple of reasons for this. One is because, you know, the bottom line is we don't want to do anything that undermines somebody's criminal case. We don't want advocates to be put in the terrible position of being potential witnesses against survivors. And you know, that sounds paranoid, that sounds conspiratorial, and we've seen it happen before, okay? We've seen it happen where the information that a defendant tells an advocate ends up getting subpoenaed by the prosecution, and the advocate being used against the survivor in that criminal case. I understand, I'm not very familiar with the confidentiality laws in Washington State, and I realize that VAWA gives a strong advocate survivor confidentiality under federal law. But the fact of the matter is that sometimes there's loopholes. And so it's just best practice to minimize the opportunity for somebody's information to become vulnerable. So when we say that somebody's words can and will be used against them in a court of law, you know, that's what that's all about. So advocates can really help victim defendants protect their legal rights and options by making sure that they know that it's only safe to tell their stories to their attorneys. We got a call a couple of days ago. Okay, I'll get to the moral of the story later, but we got a call a couple of days ago from a program, not in your state, somewhere else, but the executive director of that program received a phone call from the district attorney asking them for some confidential information. The executive, for the court, for the investigation into a criminal case. Okay, so I don't know this to be the case, but what it sounded like is that they're investigating a survivor for some crime. Okay. So the executive director, of course, didn't confirm or deny anything. Basically said that they couldn't say whether or not they were working with any particular person, and that they weren't trying to be unhelpful, but that's the law, and left it there. And the district attorney said, well, we're going to get that information one way or the other. And the executive director said, well, I can't do anything at all without a subpoena. And the district attorney said, oh, I'm not going to subpoena you. I am going to get a search warrant. And so what that district attorney is intending to do is to get a judge to sign off on a search warrant to allow the police to go into this shelter program and get whatever information it is that they're trying to get. Now, there's so many reasons why this isn't okay, but that doesn't mean it's not going to happen. And in fact, if the program wants to prevent it, it's easier to try to quash a subpoena, to go to court and ask a judge to do that, than it is to refuse to honor a search warrant. If the police articulate probable cause in their search warrant, say what it is they're looking for, and say where it is they're looking for it, programs options are very limited in that moment. So you can go to court afterwards and try to get some, legal ruling that the search was illegal or whatever, but the damage has already been done. The survivor's information has already been compromised. So to the extent that we can make sure that, we're not asking about details of a criminal case or a criminal investigation, we're certainly not writing it down. That's the most protective strategy moving forward. And if anybody wants to talk about that further, I'm happy to. I know that there's definitely situations where this feels particularly complicated, and I'm happy to talk through any scenario with anybody about this. It doesn't mean that you can't talk to survivors at all. Everything else is on the table. How she's dealing with the incident that happened, the criminal process and what to expect in that, which I'll talk about more in a couple of minutes. Safety planning, all these other things. There's a lot of work that advocates can do with survivors, even if they have to avoid the incident that somebody got charged for. One of the more common concerns that I've heard from advocates when we're talking about avoiding discussion of somebody's incident that they got arrested for is that allowing a victim to tell their story is, part of the bedrock of advocacy. Advocates hear survivors who have never, ever been heard before. And so it's really hard to tell somebody, no, I don't want you to talk about that with me. Well, related to that is helping to inform and manage expectations around whether or not the victim is going to be heard in court. Victims, who really want their story to be heard, thinking that once people understand, then I won't be in trouble anymore. That's a very dangerous fallacy for survivors to believe, okay? So advocates can be crucial and instrumental in helping people to learn that criminal court as a defendant may not be the place where that story gets told. There's if somebody takes there's going to be a lot of situations where attorneys advise their clients not to take the witness stand. This isn't to silence victims. This is to protect victims, quite frankly, and this is to protect victims' legal rights and options. If the prosecution can't make out their criminal case without the words of the survivor, then the survivor doesn't. There's no reason the survivor needs to get on the stand and expose themselves to cross-examination and to harmful facts being revealed. So advocates can help survivors find different, more appropriate, more safe places to make sure their story get told after the criminal case is over. If a survivor is going to be testifying, advocates and attorneys and the defendant herself need to work really closely together to get her ready for the experience of being asked questions and cross-examined about what may have been one of the worst days or nights in their life. Along with being really circumspect about where a survivor who's charged story gets told, is to the prosecutor. We have a lot of victims that call us up and tell us that they've written a letter to the prosecutor, or their advocate knows the prosecutor. They're on a first name basis. They go out for drinks sometimes, and they're going to get my case dropped. And this strategy can work sometimes. And obviously, advocates want to do whatever they can to get victims out of the system as soon as possible. However, this is another strategy that, unless the defense attorney is fully on board with it, can backfire in fantastic and dramatic ways. There's a few reasons for this. One is that if an advocate is they get a release signed, whatever it is, they go to the prosecutor, they explain that what happened was an act of self-defense or whatever it was, the advocate may be revealing information that was not only unknown to the prosecutor before, it is actually harmful to the criminal case. I have a couple of examples of that. One is, an advocate goes to a prosecutor and explains that yes, the complainant had a black eye, but that's only because she punched him in self-defense. But that prosecutor had already met with the complaining witness whose eye was not black anymore, and she decided that that complaining witness was a creep or not truthful or an abusive partner or whatever it is, and had planned on dropping the case, believing that nothing happened. But once they get confirmation that that punch in the eye did happen, they decide to proceed with the charges. I remember I had a case where a young man was accused of beating up his boyfriend in a public park. He was arrested on a warrant a few months after the incident in the park happened. I did my investigation and I found out that my client had an incident in the park with his abusive boyfriend where he did end up having to fight to defend himself. But when I dug a little deeper, I found out that my client had a rock solid alibi for when this incident had supposedly taken place. So had his advocate gone to the prosecutor and explained that it was all one big act of self-defense, that would have undermined my alibi defense, which ended up getting the case dismissed before I even had to put on a defense. So it's just a really risky proposition unless the defense attorney is on board and knows what it is you're going to be talking about and agrees with that particular strategy. And another reality that it's important to acknowledge is, and I'm not saying that advocates should not work together with prosecutors, but in a lot of communities, advocates and prosecutors' offices have worked together for a number of years and are very aligned. And so there might be some distrust coming from the defense community when advocates show up supporting victim defendants. So in order to chip away at some of that distrust that might be there from having this court culture where it appears that, the victim advocates work only with the prosecution, is letting the defense attorney, in on advocacy actions like that, like with the prosecutor. That can definitely help to try to build trust.
Yeah, we had a question from Brooke. What about when survivors want to seek a civil protection order? Usually their public defenders are not willing to give us any advice. I wouldn't want to put anything in there that would be able to be used against them. So I'm guessing a victim defendant who wants to then file a civil protection order.
That's a great question, and it does come up a lot. And when that happens, we actually have a resource about this exact issue on our website, which I can send to you, Heather, if you want to send it with the PowerPoint when you send that around to folks. But yeah, it's something to be very cautious about and to know your local laws around. There's a couple of states, I don't think Washington is one of them, but don't quote me on that, that make sure that nothing in a civil protection order petition is admissible in any way in criminal court. That's rare. Usually it is completely admissible. So if a defense attorney is not going to give their clients advice about that, I think it could be really helpful for advocates to reach out to defense attorneys to say, to ask about A, the downsides, and B, like if the victim is going to do this, regardless of what the defense attorney advises, to see if they can give some input on how to craft the petition in the way that's the least dangerous. Okay, is there a way to craft that petition in a way that doesn't undermine somebody's legal rights and options? For example, can that protection order be based on an incident that the defendant didn't get arrested for? You know, something completely separate from the reason that they're in court. That might be one option. Another option might be to see if there's a way to get a temporary protection order, knowing that that hearing is not going to happen until after the criminal case is already disposed of. So there are some ways to navigate that, but I think it's so good that it's on the radar that getting a civil protection order might not be a solid strategic move, legally speaking, when it comes to that criminal case. And I will send that resource around for people. And it goes through a number of scenarios about defendants who want a civil protection order based on that incident, whether they're the respondents in a civil protection order, all kinds of things. So hopefully that can be a little bit of a guide. I mentioned that one of the things that it's not only safe, but really good to talk with survivors about when they're facing criminal charges is about the system in your community. And I'm going to spend a couple minutes talking about that, even though it seems like a bit of a no-brainer, but honestly, as far as pretrial advocacy is concerned, this one is one of the most important. I mean, it's right up there with not talking about the facts of the case and not going to the prosecutor without the defense attorney being on board. And that is making sure that the defendant has as much information as possible, not just about the criminal legal system, but about the criminal legal system from a defense perspective. And this can be especially true if that survivor has been involved in the system before, but as a complainant. In other words, if they've ever come to court against their abusive partner before as a witness for the prosecution. We just see it over and over and over again, and this goes for people who are out on bail or who are held in jail pre-trial. The more information victim defendants have early on, the better they are. The anxiety comes down, and they're able to really work with their defense attorney in a meaningful way to prepare their defense. And honestly, no detail is too small to be helpful. People can go from crisis mode to being okay to proceed just by having a little bit of information. And that, God, this can be especially true in this world where Sometimes court is happening 100% electronically. It's interesting. I've given webinars about other things like COVID related and that kind of thing. But I haven't done one specifically about advocacy since the beginning of the pandemic. So it's just interesting to look at some of these details that it's really important to know, and to think about how those might be similar or different or need to be adjusted in a world where court may happen over Zoom. Uncertainty can really, can really be somebody's worst enemy, especially in early stages of court proceedings. A question that victim defendants often have is, are they going to have to say or do anything when they first go to court? So if you know the procedure in your community, you're going to know the answer to that question. Maybe they'll fill out a paper that gives their personal information, or maybe the judge is going to ask them in front of everybody. Knowing that ahead of time is absolutely huge. A lot of victims, especially those who have never been in trouble before, you get your entire legal education by watching TV, and so what you think is that you go to court and everybody gives their side of the story and the jury makes a decision, and that's not exactly how it works. So if victims can know what it is that is going to happen once they get to court, or once they turn on their webcam, that can really take that anxiety from a 9 down to about a 6 and help them be able to proceed from one step to the next. Another thing that I used to hear all the time, obviously not just from victim defendants, but all defendants, is they don't know who the hell the people are who are sitting in the room. I mean, they know who the judge is because judge. They know who the district attorney is, but there's a million other people in there. And if this is the scariest thing you've ever done and you're terrified of going to jail and you are dealing with something very personal and very serious, it's really hard when there's strangers present. So being able to describe the stenographer and the court clerk and the court crier and the judge's personal and whoever else it is that based on your experience might be there, that's also really helpful information to have. The process of getting a lawyer. Every community is different. Does somebody get assigned a lawyer at their first court date, or does it happen in a different way? Is there a paperwork proceeding they have to initiate themselves, or is the judge going to ask them about how much money they make? Where should they sit? What should they wear? Should they bring their kids with them? Or really, can they bring their kids with them? All these things might seem small, but they're pretty huge for people to have that information going in. And if somebody has never met their lawyer before because they're not assigned yet, or there hasn't been time, or whatever the case may be, they don't have anybody else to ask for some of these most basic things. Victim defendants, again, whether or not they're in jail, pretrial, or on bail, need to be prepared about if and when they're going to see their abusive partner. So if it's a pretrial hearing, knowing whether or not the complainant is going to be subpoenaed to show up is a really helpful thing to know. If the courtroom is designed to seat defense family in one area and complainant family in another area, that's also good to know when something gets closer to trial, just to be prepared for more than anything else. So again, these little details. Signing subpoena. What happens if you don't show up for court? If you're a complaining witness and that's been your experience, you might just get a subpoena for the next time. But if you're a defendant, you might get a bench warrant. So it's not just knowing the system, it's knowing the system from a defense perspective. When somebody's court proceedings wrap up, either because they're found guilty or because they're acquitted, that's a time when advocacy is tremendously needed. for some defendants, that's, if they're acquitted or if they're, given a probationary sentence or whatever it is, that might be the first opportunity they have to move forward and start rebuilding their life. So being able to answer questions like how to get bail money back, how to meet a probation officer for the first time, whatever it is, advocates can be instrumental in that. I know that there are players in the criminal legal system that are supposed to be the ones doing this work, but they might not have the same kind of trust relationships with victim defendants as their advocates do. Helping people who do get put on probation to navigate the probation requirements can be huge. I can't, it's been a number of years since I've been in the courtroom, that's true, but seeing a defendant sentenced, not sentenced to jail, but then given a stack of papers and sent on their way, expected to know what their next steps are, is really something that sets people up for failure, and advocates can really be an incredible bridge between defendants and what they need to have and what they need to know to comply with their probation conditions. Re-entry is something that often gets talked about in the context of people returning to their communities after serving time in prison. And it is that, but it is also people returning to their communities after being held pre-trial, okay? So a lot of cases end up getting dismissed or end up getting thrown out for whatever reason. Maybe the complaining witness didn't show up for court. People in those circumstances often aren't directed to the same resources as people getting out of jails and prisons as far as reentry goes, although they might have the same needs, like things that people in anti-DV programs work on all the time, including housing, identification, sometimes treatment plans. All these things are needs that people have, and sometimes there's nobody to provide those things except for anti-domestic violence programs, whether that's providing those services within the organization or getting them to the right places. When people are acquitted or people's cases are dropped or whatever it is, as I said, they're not identified as the people in need of reentry support and services, even though they're very much in need of it. Part of some reentry programs, although not necessarily everybody's, involves figuring out what to do about a criminal record, or even if there is a criminal record. Okay, so for a lot of people, whether it's something that's brand new or something that's 30 years old, what's actually on somebody's individual criminal record can be a bit of a mystery. Somebody might get charged with aggravated assault, but end up taking a plea deal to disorderly conduct. So if they're asked a question when trying to get a job about being convicted of a felony, they might not know the answer to that because they were charged with a felony, but they were convicted of a misdemeanor. So helping people know what's on their record and how to read their record is a huge deal for helping people move on. Advocacy programs who have good relationships with organizations that do expungement, that's an incredibly valuable thing. Because sometimes, even if a case gets thrown out or somebody gets acquitted, it doesn't mean those charges disappear off of somebody's record without the defendant doing something. And so advocates can really help people make sure they know what that something is. Even though arrests without convictions aren't supposed to be considered in most employment situations, they just are. So getting them wiped off where possible and when possible eliminates an extraordinarily big barrier for survivors who are trying to return to their communities and get a job. These advocacy strategies are all good and fine, but it goes without saying that there are some barriers that get in the way of being able to perform these strategies in the real world. And we don't want to ignore those and pretend that they don't exist. And this is one area where if you want to talk about what's going on in your particular communities, I would welcome that, because trying to navigate some of these things can be really community specific for sure. As we talked about a little bit earlier, we know that it's not like this everywhere, but we know that there's a lot of places where the anti-domestic violence community is very, works very closely with the police and with the prosecutors. You know, and historically, this kind of partnership took some effort to build over time, and it happened because the anti-DV people were saying that the police and prosecutors needed to be involved to help protect survivors who were victims of crime in their own homes. Because that wasn't a given 40 years ago, even domestic violence being recognized as a crime. And the people who were doing that work did a really good job, such that now in some communities, the anti-domestic violence advocates are pretty entrenched with the prosecutors. And so the idea of working with defendants sounds like a non-starter, because there's going to be a lot of messages out there when the advocacy program and the prosecutors are at least appearing to be in lockstep. And that's that advocacy services aren't available for defendants, but also that defense and defense attorneys can't be trusted. So by working with defendants, sometimes people are concerned with displeasing the people, the police, the prosecutors who have been their allies for a long period of time. I can't tell you how many times we've gotten calls from victim defendants who have tried to get services from an anti-DV program to be told that that program can't help them because they don't work with perpetrators. Okay? And I don't know if this happens at all in your state. I know that Washington has been doing great defense-based work for a long period of time, but this is an example of where the criminal legal system's assignment of who's the perpetrator and who's the victim takes priority over the realities that are recognized by anti-domestic violence advocates. And that line drawing happens and victims don't get services because the criminal legal system says that they're abusers. And so what we tend to do is call the program and have a talk with somebody about if that's an actual policy of not working with somebody who's charged. And sometimes it is. But sometimes what happens is we find out that the information about working with defendants just never made it to everybody. That the culture of working so closely with the prosecution was so ingrained that the person answering the phone never thought to ask, well, do we work with defendants too? So challenging some assumptions, making sure that they're, you know, if they're rooted in real policies or if they're just assumptions can be critical. Because a lot of times those no's turn into yeses. And then, you know, programs are inspired to take a closer look at, you know, if they're meeting their professed mission statements of working with all victims. A lot of programs are worried about funding restrictions, and I get it, man, it's real. Luckily, there's a lot of funding streams that don't place any restrictions around working with defendants. VOCA is the one that comes up most often as being restrictive about working with defendants, but VOCA has changed a lot in the past number of years to really, they've really broadened their horizons around who programs can work with, but it's pretty rare that programs only receive VOCA funding. So even programs who feel really limited by their funding streams may find that some of them don't actually prohibit defense-based work, and therefore that work can be done under those less restrictive grants. One of, the last piece of fairly common resistance that we hear about that I have on the slide is something that maybe is a little less tangible than it seems. And that involves where people and programs and systems do their line drawing about who they consider to be a victim and who they don't. And I'll be a little bit more specific. So programs over the years have been pretty on board with an understanding of the idea that sometimes victims have to use self-defense. But when allegations against survivors get a little harder to understand, that's when we see line drawing happen. And it's important to say this out loud because there's not a charge that somebody can face that is going to definitively tell you whether or not somebody is a victim of ongoing battering. Some of the ugliest charges out there get levied against people who are experiencing intimate partner battering. And it's really, really hard a lot of the time to see somebody who's accused of terrible things involving children, terrible things involving other people. It's hard to keep their experiences of abuse and their need for advocacy and support centered. But the minute we start siloing victims into victims deserving of advocacy and victims who aren't deserving of advocacy, we're probably leaving out the most marginalized people, the people who need support and services the most. So just keeping our real close eye on where we might be doing line drawing about who we consider a victim, who we don't, is really important. That way we're making sure that we're fulfilling, our missions, and that advocacy and support and services aren't just getting to the people who are easy to work with, that they're getting to everybody, even those who are most struggling and most marginalized. I've used the term court culture a couple of times in this presentation, and I want to circle back to it and talk more about what I mean. And I'll do that by telling you just a little bit about my experiences when I was a public defender. When we were pretty brand new, we would often get assigned to, it was disgusting, but we would get assigned to what judges and everybody else referred to as love court, which was where misdemeanor domestic violence trials were held and felony preliminary hearings involving domestic violence were held. And I got that rotation a lot for whatever reason. And, I would go into court with all of my files and I'd set them down on the defense table. And I was one of the first people there. And as people started to trickle in, I would try to figure out who my clients were, if I hadn't already met them, and some of them I hadn't. And meanwhile, the prosecutor and their staff are doing the same thing. So there's just me on the defense side, and then there's 3 people from the prosecutor's office going around and and doing the same thing, trying to meet the complaining witnesses and check in the police officers and the other people who are expected to participate and testify. And then while the trial is happening, the main prosecutor is sitting at his or her or their counsel table, and the other two people from the DA's office are sitting in the jury box, sometimes answering the phone, sometimes helping complaining witnesses get subpoenas, sometimes going in the back to chat with the judge's staff, whatever it is. And it was a very long time before I found out that those other two people who worked for the district attorney's office didn't work for the district attorney's office. They were community-based advocates who were there to support victims who were going to be testifying against their abusive partners. I had no idea that they were a potential resource for the victims of domestic violence that I represented on my side of the courtroom. Nobody told me that they weren't available for that, but nobody told me that they weren't. And the optics told me that not only were they an arm of the prosecution, but they were friendly with the cops and friendly with the judge, and therefore something that I wanted nothing to do with for my clients. So regardless of what policies are, what does it look like your policies are? Because that can make all the difference between a defendant knowing that they can access your services and getting the nonverbal signal that they actually can't. A lot of communities, you know, this goes along with what I was saying before about historical relationship with police and prosecutors. That in and of itself can breed distrust with defense counsel. Obviously, the other thing that can breed distrust is that advocates see abusive partners being represented by defense counsel, and that can just feel completely off, right? And so barriers can get raised between the defense community and the advocacy community, and it can be really hard to break that down. But one way to do that is clarity about role. And if somebody is invested in defense-based advocacy, they're going to have clarity about role. Like, defense attorneys aren't there because they want to put dangerous people in close proximity with victims of crime. You know, they're there because those defendants need just as much support in leveling the playing field against the state as do other defendants. So defense attorneys have their job to do too. They need to have a more nuanced and rich understanding of what it is that anti-DV advocates do, that they're not an arm of the prosecution, that they're not a phone answerer for the district attorney sitting in love court, and that they're not there to just, you know, completely support people on the left side of the courtroom and not the right. So, you know, these are the things that have to be taken head on when we're going to do this work. And I've woven these strategies into what I've been talking about for the last 20 minutes or so. But if we're going to do defense-based work, it really is worth it to take, you know, to take a beat and to see what is standing in the way of either getting the work started or to institutionalizing it into the work that DV programs do every single day. Taking a look at optics can be a huge part of that. And as I said at the beginning of this presentation, you know, it's good to work with defendants, but it's even better to say out loud and explicitly that you work with defendants, because of all the assumptions that get released into the ethos from working closely with police and prosecutors, we have to be explicit. We have to let defendants know that our services are available for them as well. One of the slowest and most inefficient but most effective ways that I've seen advocates create relationships with defense attorneys is by calling them. It sounds so banal, but honestly, when they meet a defendant, asking them who their attorney is and calling that attorney up on the phone, working with that, especially for the more serious cases, I've seen this happen, explaining and being explicit about what you as an advocate can and can't and will and won't do at the beginning, and really becoming a part of the defense team like that. That's what builds that kind of trust. That's what helps dismantle those kinds of barriers. And that kind of relationship with just one attorney or just one public defender's office is definitely going to have a ripple effect for sure. I have on here recognition of shared values and principles in this wonky font, but I realized that I didn't include the slide where I actually name what those principles are. So I'm gonna do my best to recall all of them. I may or may not be successful. But anti-domestic violence professionals and defense attorneys both believe that people deserve to have self-determination in their lives without the oppressive power and control inflicted upon them by any outside oppressive source that can limit that self-determination and prohibit that autonomy. So whether we're talking about intimate partner violence, whether we're talking about state violence, anti-domestic violence advocates and defense attorneys hold freedom and hold liberty very, very closely. Anti-domestic violence advocates and criminal defense attorneys often find themselves in a situation where they may be the only person who's fighting for and who appears to care about their clients. And they're proud to be in that position because it's an honor. You know, it's an honor to support the person other people aren't supporting, to believe the person that other people aren't believing. And advocates and defense attorneys both do that. So there's common ground to be found. The principles are the same. The desire to see a world where people aren't oppressed is a shared value that is relevant in anti-domestic violence work, it's relevant in criminal defense work, and it's relevant in the world we live in today. We're seeing that principle in operation, you know, on our streets, in the media, in our communities, and in our hearts and minds, I hope, and I think, and I believe. So where we, you know, for a system that has seemed to be in opposition for so long, it's just not true. It's just not true. Are we working in an adversarial system when we're talking about the criminal legal system? Yes, but that doesn't mean that our shared principles and values are any different. So we can do this work to support victim defendants and to make sure that we're doing everything we can to get them out of the criminal legal system as soon as possible, with their rights and options and safety as intact as possible. We are happy to work with you on a given case. We're happy to work with you if you want to figure out how to institutionalize some of this stuff in your programs. If you just want more information, take a look at our website, give us a call, email, anything you want to do, we would love to be working with you. We have about 10 minutes left, and I should have saved a little more time than that, but Heather, if there's any more questions right now, I'd be happy to address them. Thank you so much. Heather and everybody for inviting me to talk with folks in Washington. I was very excited to do it and very happy to do it.
Great, yeah. I mean, there's one question here that came up that I don't know if you could give, if you have a general answer. Someone said, what's your sense of how common it is for survivors to be arrested for DV-related crimes? I was just going to add, as someone who's done LGBTQ community-specific advocacy, that in that community, it is extremely common, since law enforcement often can't determine who the primary aggressor, however they talk about it. But then it also is disproportionately impacts folks, I think, based on identities, at least is what I've seen. And so that's all I was going to add before you can say whatever you've seen from your work.
Yeah, sure. It's really common, but it does vary a lot from community to community. And that's for a number of reasons. I saw somebody bring up mandatory arrest in the chat. Mandatory arrest is something that definitely increases the number of survivors who get arrested. In communities where there's a lot of dual arrest, obviously we see a lot of survivors getting arrested, and there's very rarely, at least from what we see, there's very rarely a really robust self-defense analysis that happens when investigating these kind of offenses. And so what tends to happen is that police officers look for injuries, and whoever's got the worst ones are considered the real victim. But a lot of the most serious kinds of harm that comes to people doesn't leave a mark that police officers can readily see, whether we're talking about suffocation or strangulation or sexual abuse or whatever it is, whereas defensive actions like scratching and punching and biting, those leave marks. So from the outside looking in, an officer might conclude that the person who's not exhibiting any injuries is a perpetrator of violence in that scenario. The other thing that we see happen is that people who are victims sometimes have a tendency to take over responsibility for an incident that just happened. And people who batter their partners never take responsibility for what just happened. So something might sound like a confession when it's actually just a victim doing whatever it is they have to do to de-escalate.
Maybe we have one more question. Are there any written tools or trainings for prosecutors and/or judges for identifying victim defendants that you're familiar with?
That's a good question. For judges, yeah, I don't know. There may be, and if there is, we don't have access to that. As far as prosecutors go, I believe Equitas has resources about trying to identify victim defendants. As far as judges, I think we were involved with some of the judge training a number of years ago, but it's definitely been a long time. So what's available to them and bench cards and that kind of thing is a bit of a mystery to me now. But I would check out Equitas's website for information about including context in their charging decisions and, trying to promote justice and not just convictions. I think they have a resource about that.
Looks like that's it. So thank you so much for your time, Cindene. This has been really valuable information for everyone on the webinar, and I'm just so glad that it all worked out and we were able to have you. And yeah, thanks for your piece.
Thank you very much. It was definitely my pleasure, and I look forward to hearing from anybody who wants to reach out. Enjoy the rest of your fine summer Thursday.